Learn more about business immigration. Coming up next. Welcome, bienvenidos. My name is Carlos Valderrama of the Volusia Hispanic Chamber of Commerce. This is our Negocios Today segment show. Today we have a guest, a board-certified immigration attorney, David Vedder. Welcome to our show.
Well, thank you for having me.
So I know there's a lot of topics to talk about immigration. Immigration is so vague, and we want to focus a little bit more about business immigration. So tell me a little bit more about the different types of visas that's out there.
The area is generally divided into, I guess, two segments. Investors, and there's two different visas available there, and what we also call employment-based immigration, which is generally where the alien worker is sponsored by the employer.
Okay.
And I guess a third category would be a variety of temporary or non-immigrant visas.
Okay. So the investor visa, let's go back to the investor visas. What different types of investment visas are out there?
There's two. On the immigrant side, and when I say immigrant, we mean that the worker, the investor, is going to get a green card,
Okay.
permanent residency. And the primary vehicle for investors on the immigrant side is a category called EB-5. Interestingly, the statute calls them entrepreneurs who create jobs, job creation.
Okay.
And in that category, the immigrant is required to invest either $500,000 or $1 million, depending upon where, and prove the creation of 10 permanent full-time jobs. And if those criteria are proven, the Immigration Service issues a temporary green card, a 2-year green card, and then after a 2-year conditional residency, a permanent green card.
Would this qualify for the relatives or just for the investor itself?
They bring with them, like all immigrants do, spouses and children. And when we say children, we specifically mean under 21 years of age who are single. So when children reach 21, they age out. So one of the things we do is watch carefully the ages of the children. If somebody comes to you when the children are 19 and 20, you have an age out problem, don't you? So you got to watch that carefully. If the child is under 21 and single at the time the green card is issued to the parent, the child gets a full green card. If the child's either married or over 21, they're out of the case. So it makes a significant difference.
Is there a specific industry that it should be, or is it basically any job creation of?
No. The EB-5 program is very flexible in terms of what industry. Obviously, it must be a bona fide entity that's being invested in, a lawful enterprise. But other than that, no, there's not. Now, Carlos, there are two sub-varieties. One are what we call individual cases, which is a typical example is the investor stands up his own business, okay? He invests money in his own business, and he himself, through his business, creates the 10 jobs. The other type of EB-5 case is when you invest in a regional center. Basically, you're investing your money in somebody else's business. They create the jobs, and you're really no more than an investor. You don't play a role, a management role or otherwise in a regional center case. So there's two different ways to do it, and both of them can be effective tools depending upon the circumstances of the need of the client.
So there's no learning curve to learn more about the industry or learn about the region, or so is there a percentage of interest that have to be in for that investment?
I'm not sure what you're saying.
Whether if they were to invest on an existing business or a new entity,
right.
Is there a percentage of interest they're supposed to have? No.
They can have a minority stake in the business, but you have to be careful. It must be what we call a new business. So you can't invest in a business that was around before 1997. So it must be a new business, and you got to be careful about jobs that are already there. you're supposed to be, by the investment of this capital, creating new jobs. So in an existing business, let's say you bought an existing business that already had 5 jobs. Well, you got to get to 15 jobs because you're supposed to add 10. But if you partnered with somebody, there's no requirement that you have any particular amount of interest in the business. No, very flexible in that way.
Okay. So, and what other type of visa is out there?
There is a visa called E2, Non-immigrant Treaty Investor, and it's more restricted in that the applicant for the visa must be the national of a country there is a special treaty with. It's called a treaty of commerce, and we don't have them with all countries. For example, there is notably lacking such a treaty with Venezuela. So a Venezuelan investor could never become an E2 because they're not the national of an E2 country. So what often happens, this is a good example, with Venezuelans, many of them are eligible for Italian citizenship. Absolutely. So they obtain an Italian passport, okay, now they're a dual national, let's say, and they qualify for an E2 treaty investor visa because they're now an Italian national, and the United States has the commercial treaty with Italy. So when you're managing one of these cases, you always, what about spouses that may have different nationalities?
Exactly.
What if my primary husband investor is from Venezuela, but his wife has an Italian passport? So you switch the investment to the Italian national who invests in the business. So there's some flexibility in that way.
Does your office assist the process in order to be national of another country?
No.
Okay.
We always recommend they turn to the consuls of their own country.
Okay.
Our practice is limited to U.S. immigration law. So if somebody comes to me and says, "Can I be a citizen of Italy?" I can't be helpful to them.
Okay. Okay. Now, is there a limitation of investment on the E2s, or?
The E2s are not limited by number, and you get a lot of different opinions about this.
Okay.
And I have my own opinion. I've been doing this for a very long time, and I've handled lots of cases. So my own opinion, and I stress the word opinion, is that if an investor has less than 100,000 US dollars to invest, the case is small. And if the case is small, there's a lot of consular resistance to visa issuance because of all sorts of related problems. And I'm not saying 100,000 is a magic number, but I am saying that we see a correlation between investments that exceed $100,000 and visa issuance. And at the end of the day, the investor necessarily wants the visa to be issued. And Carlos, I think a good thing to talk about whenever you talk about E2 visas is what I call the problem in circuity that affects almost all of these cases. Here's how the problem manifests itself. A prudent consul does not want to give an E2 visa to an investor unless they're fully invested, the money is here, they're sure the guy is going to go through with the plan. Now on the other side, the investor doesn't want to commit money and own a business unless they have some assurance they're going to get a visa so they can stay and work in the U.S. And almost every E2 case has this, what I call a problem in circuity. And you must be very careful to break out of that. And here's how we do it in most cases. The contract to acquire the target business, okay, is entered into with a contingency clause. And the clause says in it something like, this contract is contingent on the issuance of a non-immigrant treaty investor visa within 90 days of the date of the contract. And if the visa is not issued, the investor, the contract party, the buyer, can get his deposit back and the contract is declared null and void. It's a contingency clause.
Yeah.
If the visa is issued, the consul will issue the visa, then you close the deal to invest in the business. If the consul declines the visa, well then the investor, the buyer, can back out of the deal. So that's a very significant trap
Yeah, it
that you
is.
can fall into if your client comes to the States first and invests in a business and they're now totally bound. And then they call you and you say there's some reason why it can't be issued.
So I guess a word of advice will be see an attorney first before
Yeah,
you
you
actually
can
make
fall
that
into a
investment.
trap. Yeah. But back to amount. It's a fascinating topic because there's one lawyer, I really love this one lawyer. She's very smart and she's very educated and skilled. And we have these seminars where all the immigration lawyers gather and they discuss these topics. And she stood up and she said, I got a visa in Paris for a guy who invested $6,000 in a consulting business. And I said, whoa, I've never seen that. But I don't want to lead any of your viewers to think that $100,000 is written into the body of law. It's just my own advice that when you're below that amount, you're going to have issues that might indicate you're not going to succeed.
Wow. So in regards of the employment-based immigration, what's out there? I know there's talks about different things out there.
Yeah, it's divided basically, and there are some oversimplifications necessarily to get this out. It's basically divided into three large categories, okay? Mm-hmm. And I guess, and for the most part, it is predicated on sponsorship by a U.S. company, okay?
Okay.
Typically, it's an alien worker who is being offered permanent, full-time employment by a U.S. employer. There is no requirement of law that it be a mega company, but it must be a bona fide job. So they have to have a real position, the ability to pay the worker, and it has to be all on the up and up, or no status could be ever granted or anything less than that. So we got to start with a bona fide employer that has a real position for a worker. And at the lowest level of that pyramid are what we call skilled and professional workers. It's the employment-based third preference. Since almost everyone qualifies as a skilled worker or a professional, it is the residual category. Now remember, Carlos, only 140,000 of these visas for workers are issued per year. And therefore it's very competitive, and it's under what we call a quota, which is designed to allocate the numbers on a first come, first served basis. So when you're in the third preference, you're going to wait years, not months, but years for a green card. And since most workers are in that category,
right.
Okay, not all the workers, we'll talk some more. Since most workers are in that residual third preference category, and there's not enough numbers available, you see long waits. Now, help me out with this, Carlos. You're in the Chamber of Commerce. How many businesses who need a worker are in a position to wait years?
By the time
so
you already fill that position.
Yeah, so that's one of the many things we can point to when the people talk about a broken immigration system. One of the things that's in this mix is how long it takes to get a skilled worker here. And a whole debate has spun out of that in the way they count the numbers. Mm-hmm. And there has been recently, somebody looked at the law and they said, well, gee, the law doesn't say that you count the wives and the children against 140,000. The wives and children ought to be free, not counted against the core count. Right?
Right.
Think how many more people would come if wives and children weren't counted, because if one person gets a job and he has a wife and 2 children, 4 numbers are taken down out of the system, right? So families take down numbers. So somebody said, well, gee, the law doesn't say that. Whenever you read the law carefully, there's nothing in there that says that wives and children should be counted. And so now the new debate that's out there is, why are we counting everybody? The second problem that arose is kind of interesting, was that they figured out that every year there's a residual number of visa numbers that aren't used because of the Department of State or systemic inefficiency. Not used at all. Well, the Department of State has long told us those numbers disappear. You can't recapture them. They're gone. If you don't use them in that year, So somebody's saying, now wait a minute, we can recapture those numbers. So the Obama administration has made some indications. They're looking at how we count who is going through this 140 to try and get more people out of it. Because your members of your chamber, if you said to them, it's going to be 3, 4, 5 years to get a worker, they're going to say,
forget it. Exactly.
Yeah, but the next tier up is better. The next tier up includes workers who have master's degrees, okay, a master's degree, or they're workers of exceptional ability. And when we start to get to this elevated category, the numbers are available. So if you are employing somebody who has a master's degree or the equivalent of a master's degree, or your alien worker is a worker of exceptional ability, numbers are available at that level. So obviously the game is to try to qualify your worker in the elevated second preference category to get them in here within a reasonable amount of time.
Here's the question. There seems to be a lot of foreigners coming in to study in the U.S. and they're going through a graduate program. Upon graduation, they're looking to be employed. This will be possibly a great scenario for a potential employer that find these qualified candidates that have already finished a degree for them to qualify for that employment, high education, I guess, to fill those positions. And so do you get a lot of cases as such?
Yeah, absolutely. And when the student graduates, if they've taken a full degree, let's say, for example, a bachelor degree, they're entitled to 1 year of optional practical training. We call it OPT.
Okay.
And that basically is work authorization as long as the student is working in the field in which they were educated. They can stay here for 1 year. And it gives them a great opportunity to go into the job market, to locate an employer, and to work for up to a year. And if that student took a science, technology, engineering, or math degree, we call that STEM degree, the OPT authorization is much more lengthy. They can get a much more substantial extension, but everybody else gets 1 year. So the student has a real nice segue into permanent employment. Now, you've got to get them into a category that they can continue to work seamlessly is, of course, the employer's goal. You often use H-1B visas, which are constrained by the congressional mandate that only 65,000 new H-1Bs can be awarded a year.
Oh, wow.
And it's nowhere near enough. I mean,
exactly.
It's like, I think Microsoft alone applies for 15,000. It's like we have 140,000 typically apply each cycle. Well, it varies, but certainly way more applications are filed than 65,000. And so the H-1B program is constrained. And one of the things that the people who want to reform employment-based immigration would like is more H-1B numbers. Because we're talking about college grads, we're talking about workers with college degrees, high levels of skills, who have a sponsoring U.S. employer, who are, by the way, being paid the prevailing wage. So wages and working conditions of American workers are necessarily not being undercut by this. So it's very protective of labor, the program. And so it's win-win, really. And what ends up happening, you get all these smart kids who become highly skilled, who stay in your country, which seems to me a very positive thing for us economically, well, culturally too, I think.
So that 65,000, I guess, applicants, does it every year renews? Or?
Yes, it does.
Okay. Is there, what's the waiting period for those that missed it?
There is no waiting period. What the Department of State, what immigration does every year is, it starts on April 1 of every year.
Okay.
So the next one is obviously coming up in a couple of weeks. You file your application with CIS on April 1, and they take them all in. And since there's always way more than 65,000, they run a lottery. and the ones that win proceed with their application, and the ones who do not get a number, they're simply returned their deposit, I'm sorry, their filing fees, their applications returned to them, and they go for naught. They get no benefit. They get nothing. They're on no waiting list. They're not registered for anything. They're just, it's no consequence. And the ones who get the numbers must prosecute their application through from there. But most of these applications are meritorious. Most of them that receive a number, I would guess, are approved.
Can H-1Bs become permanent residents?
Yes. They can go through the employment-based immigration system, and they can get a green card through the system we were talking about. Remember, we're talking the second preference, which is you'd like to bring them in with a master's degree or aliens of exceptional ability because there's numbers immediately available. If they're stuck in the third preference, okay, then the 3 to 5 year wait becomes problematic. So the worker continues on the H, typically, and asks for extensions and extensions of the H. And generously, Congress has allowed in a law that if the worker does not have a visa number available to them and they're on an H-1B and their case has been pending more than 1 year, they can get indefinite extensions of their H-1B. So Congress has provided some relief. Not everybody qualifies for that, but many of these H-1Bs, instead of being subject to a 5 or 6 year limitation, if they're being sponsored and their visa numbers are holding them up, they can continue to work much longer as H-1Bs. So it kind of functions.
Yes.
You know, yeah, it kind of works.
Okay. Is there any other topics that's business related that we might have missed? That you
Well, you know, I don't think we also have. We didn't mention yet, Carlos, employment-based first preference, which includes aliens of extraordinary ability, like if you won a Nobel Prize or something. We love those cases.
Okay.
We had one approved recently, but it's not a large volume by any stretch. Outstanding professors and researchers are in that first category, and certain multinational executives are in that category. For example, if you have a business in Venezuela, a substantial business, and the Venezuelan business establishes an affiliated company in the United States. So now we have what we call a U.S. entity and a foreign entity. I'm using Venezuela as an example for a specific reason. There's no E2, so the people can't benefit from an E2 benefit. So if the executive officers of the Venezuelan company transfer into the United States to work permanently, they can get two benefits. One, an L1A, which is a temporary up to a 5, 6, or 7 year work visa. And two, they can get a green card in the first category. We call it EB-13 because it's first category for the 1 and third subparagraph for the 3. Wow. And that's an excellent way for you to manage an immigration case. But of course, you must comply with the regulations. You must have this foreign entity. It must be substantial employees, for real, and it must establish a substantial business in the U.S. But when you qualify in that way, it's a wonderful immigration benefit.
And it's got to be kind of related within the same industry. You can say...
No, it does not need to be in the same industry. The companies must be related. Let's say you have somebody manufacturing shoes in Venezuela in a big shoe plant, and they want to come to the United States and they want to branch out into real estate acquisition, development, speculation. It's okay. Doesn't matter. Now, it must be affiliated companies. The companies must be tied, related, closely related. But the industries are not. You need not be in the industry in the U.S. that you were involved in abroad. It doesn't. That part doesn't matter. So there's some flexibility there.
Great. So tell me a little bit more about your firm.
Well, we do a lot of immigration business immigration work, but really we are general immigration practitioners. You know, I think because of our location in Daytona Beach is probably the reason, you know, when you go to Miami and New York and big cities, what we're seeing in my field is what I call subspecialization. Lawyers, I know a law firm that does nothing but EB-5. There's lawyers down in Miami that they don't just focus on removal, deportation, they focus on criminal removal. So we're seeing lawyers that become very niche oriented. In our practice, it's really a general immigration practice in which we do removal, used to be called deportation, and relief from removal. Who should be deported when it comes down to the end of the day, and who should get relief and be allowed to stay. Naturalization is the process of becoming a citizen of the United States. We do a lot of naturalization cases. Family-based immigration is a wonderful opportunity if you're fortunate enough to have close family in the U.S. It's a wonderful way to immigrate. If you don't have family, obviously it's not available to you. We do a lot of family-based, we do employment-based immigration, we're doing asylum applications. As I've said, we've done a lot of EB-5 cases recently, so that's a very topical thing these days, but I would say that we're really general immigration practitioners.
Perfect. How can they get a hold of you? Where can they go to?
Well, Google my name.
We'll go with your name. Okay, perfect.
David Vedder.
And what's your the website?
Let's see, it's the immigration firm, www.theimmigration.firm.us.
Very simple.
Very simple.
And what's the phone number they can call?
386-274-0044.
Great. Thank you for
Well,
stopping by.
Carlos, thank you for having me. I've really enjoyed it.
Thank you. This ends our section for Negocios Today. My name is Carlos Valderrama. If you'd like to learn more about the Hispanic Chamber of Commerce, please visit feliciachamber.org. Thank you.
Thank you, Carlos.
Thank you very much.